It is really the right of every child in New South Wales and in Australia to have an education. There is overwhelming evidence that children who do not have access to education are much more likely to have poorer long-term outcomes. There is also a really strongly established link between interrupted school attendance and contact with the criminal justice system, either as a young person or later in life.
Welcome to Law for Community Workers. In today's episode, Yolanda takes a deep dive into school law in New South Wales. You'll hear from legal experts Carey and Brodie about how schools address attendance and discipline, the legal obligations of parents, compulsory schooling orders, and the supports available. You'll also hear about school exclusion, including suspensions and expulsions, and what rights students have when schools make those decisions. Throughout the episode, they unpack the complex social factors behind non-attendance, the role of schools, legal aid, and community workers, and why early, supportive intervention can make a critical difference in a young person's life.
You can really change a young person's life trajectory by getting them to re-engage with school. It's such an important juncture where a young person is considering whether to continue their education or step back from that, and the support that a community worker or another advocate could have in that space is so important.
This interview was recorded on Wanneroo land and Gadigal land. We pay our respects to elders past and present. As we share in legal learning, may we acknowledge Aboriginal and Torres Strait Islander people as the first educators, storytellers, and lawmakers on the lands you're listening from.
So school started back for the year just a few weeks ago, but for a lot of children and young people and their families, school attendance is not guaranteed. On the podcast today, we're going to be talking about school law and non-attendance from a couple of different perspectives. So where a student isn't attending school and the potential consequences of that, and also where a student is prevented from attending school because of a decision that the school might have made. We've got Carey Pearson with us. So, Carey, can you just give us one or two lines about what your background is and what your role is at Legal Aid?
Yeah, sure. So my current role is the Practice Development Manager for the Family Law Division. I have been a lawyer for 12 years now, and I've been working in family law and care and protection for most of that time. I represented both adults and children in applications to the Children's Court for compulsory schooling orders. And it became a really passion project, I think, for me. And I've spent the last probably 5 years now looking at practice and the law when it comes to what happens for children and their families when they aren't attending school.
Great. Yeah, and we will come back to what compulsory schooling orders are in a little bit of depth later on. So what are the rules around school attendance just generally? Where do they come from? What do they say?
So in New South Wales, like in all Australian states and territories, there are laws that require a child to be enrolled in and attend school. So in New South Wales, compulsory school attendance is governed by the Education Act. Under that act, the compulsory schooling age for children and young people is from 6 years old to either when they turn 17 or complete year 10, whichever comes first. However, a young person that has completed year 10 but is not 17 years old yet is still deemed to be of compulsory schooling age, so they still need to attend school unless they're participating on a full-time basis in approved educational training. So say, for example, TAFE or university, an apprenticeship, or paid work, or a combination of both.
Okay. And so what about homeschooling? It's something we hear spoken of. I know it's not super common, but can you just give us an idea of how that works?
Homeschooling is definitely an alternative education option for children and young people, and something that the education department can work with families around looking at homeschooling or distance education, which are actually two different things, as an alternative to school attendance. But that's not usually where I'm involved as a lawyer.
Yeah, of course. Yeah. Okay, it's good to know those options are there. So let's talk about what obligations parents have in relation to schooling.
So parents, and under the Education Act, that also includes a guardian or other person having custody or care of a child, have a legal duty to ensure that their school-aged children attend school or be registered for homeschooling. It's really worth noting too that it's a criminal offence for a parent to fail to enrol their child or fail to ensure that their child attends school.
Okay, so in terms of school refusal, let's talk about that. So sometimes children and teenagers are refusing to attend school. So what can parents do if their children are school refusing, or what happens if they can't make their, say, older child, like say a 15-year-old, attend school?
So in terms of what they can do, I think that it's really looking at the underlying causes of why they're refusing to attend school and looking at what supports they can get. And there is actually an obligation on the schools as well to support parents in encouraging and facilitating attendance by implementing appropriate procedures for promoting and monitoring attendance. And so in terms of what parents can be doing is really talking to their kids and trying to work out what it is that is behind the school refusal and what supports they might be able to put in place to encourage their reattendance. It's also about really talking to the school and what the school can put in place. So the principal of a school is responsible for identifying where there may be attendance issues and then putting in place appropriate supports. And that includes the appropriate support of other staff members. So for example, class teachers for the student or wellbeing officers. Where there continues to be chronic non-attendance, a student or young person can be referred to the homeschool liaison program, which is where a homeschool liaison officer is appointed to work with the family to look at strategies to improve attendance. And so what the homeschool liaison officer will do with the family is develop an attendance improvement plan. And that is really aimed at working out what are the reasons for the child or young person not attending school and what can be put in place to support their attendance. Where the attendance improvement plan doesn't lead to attendance being restored, consideration can then be given to referring the family for legal action. And so under the Education Act, there's a couple of different options as to legal action that the Department of Education can take. So the Department of Education can make an application for what's called a compulsory schooling order against the parent or the young person in certain circumstances.
And so what happens if in a situation where parents are separated and one parent is facilitating school but maybe the other one isn't, and so there's really patchy attendance? How does that work, and what sort of supports can a parent get if they're trying to get the other parent to get the child to school?
It really depends. The process is the same, and it really depends in terms of those next steps and whether there's any family law orders in place and what those say, and depending on whether the parent has sole decision making in relation to education for that child or young person. What I've seen in terms of applications for compulsory schooling orders in those circumstances has also been quite varied. I've seen applications where the department has brought the application just against the parent that the child or young person is predominantly living with, but I've also seen where they've brought an application against both parents because there was shared parental responsibility at the time. It's now shared decision making, even though at that point that child was not living with or spending any time with one of the parents. And ultimately what happened was that the court dismissed the application against the parent that was not having any time with that child. What we're seeing in terms of the applications is usually around 80% non-attendance.
Yeah, right. So really high.
Yeah.
So if you've got one parent facilitating attendance, that should cover it, and then they probably are unlikely to face the compulsory schooling orders. Now, we should probably talk about what they are. So tell us, what is a compulsory schooling order?
A compulsory schooling order is an order that can be made on the application of the Department of Education to the Children's Court, and that requires a parent to ensure that a child receives schooling in accordance with the terms of the order. So really, it's an order of the Children's Court requiring parents to do what is the law anyway, which is to send their children to school. The court may also make a compulsory schooling order against a child over the age of 12 if the court is satisfied that the child is either living independently of their parents or the parents are unable, due to the child's disobedience, to ensure that the child receives schooling.
Okay, interesting. So what are the consequences if they don't comply with the compulsory schooling order?
The Department of Education can bring an action for a breach of the compulsory schooling order, and that is undertaken in the local court. So the department can commence criminal proceedings against a parent if a parent fails to send their child to school, and that is a legal option that is available to the Department of Education regardless of whether there's a compulsory schooling order in place or not. That is 25 penalty units for first offence and 50 for a second. Where the compulsory schooling order is really relevant in a prosecution against a parent is that the penalties that can be imposed by the court are significantly higher. So where there is a compulsory schooling order in force, the maximum penalty that can be imposed is 100 penalty units, and one penalty unit is currently equal to $110. So for the stats that we've got for 2023, there were 86 prosecutions brought by the Department of Education. 55 fines were issued and 50 of those were ex parte, so where there was no attendance from the respondent.
And is it the same penalty for independent or disobedient children as it is for parents or guardians?
No, it's not. So an action for a breach against a child is slightly different. So it must be dealt with still in the Children's Court as compared with the local court. And it's only if a child is above the age of 15 years and found guilty of an offence, they can then be liable to a penalty not exceeding one penalty unit, so $110.
Right.
Unless the child has a reasonable excuse for not complying with the order. But in all the time that I've been doing this work, I haven't seen a prosecution against a young person.
Yeah, that's really good to know, because obviously there'd be a lot of different factors contributing to that non-attendance, and we hope that it would be approached holistically and supportively for those children. Do we have any stats on how many of these compulsory schooling orders the Department of Education are seeking each year?
Yes, we do. Over the last 2 years, the applications against parents have increased to around 300, a bit over 300 a year for the last couple of years. There was a sharp increase from 2022 to 2023, and then a slight increase in the last couple of years.
What proportion or number of those applications for compulsory schooling orders are resulting in Children's Court actually making those orders?
So the most recent stats that we have are from 2023. So in 2023, 313 applications were made for compulsory schooling orders, and that's against both parents and children. Of those, a final compulsory schooling order was made in 97 matters. 85 were against parents and 12 of those were against students.
Okay, so it's about a third of them kind of getting through and final orders being made. If a family is affected or a young person is affected by one of these orders, how can legal aid help? What do our policies say?
So there is a grant of legal aid available for assistance for both parents and children and young people who are respondents to applications for a compulsory schooling order. What will usually happen is when an application is made, the parents, or the respondents, I should say, will be served with a copy of that application. When they get a copy of that application, there will be a letter that provides some information about their local legal aid office and being able to contact legal aid before it is first in court. Even if a respondent, so parents or children or young people, don't contact legal aid before that first court date, there is usually a lawyer available on a duty basis at court on the first day that the application is in court to be able to assist.
Okay. And so that first occasion when it's at the court, the first time it goes to court, that's not the final hearing, is it?
No, absolutely not. So usually what will happen is the court will want to know a little bit about why the child or young person hasn't been attending school and what's being done to try and support that family to be able to restore that child or young person's attendance. One of the options available to the court is to refer the parties, so the Department of Education and the respondents, whether that is the parents or the child or young person, to what's called a compulsory schooling order conference. And those conferences are an opportunity for the Department of Education, and that'd usually be the homeschool liaison officer and representatives from the school. So sometimes the wellbeing or welfare officer or the principal, vice principal, sometimes the child or young person's classroom teacher, and also the parents. And depending on the age of the child and who the respondent is, the child or young person can attend as well. And there is a grant available for a lawyer to be able to attend one of those conferences. And it's an opportunity to be able to have a confidential conversation, to be able to try and work out what is going on for that child or young person and what can be done to support their attendance being restored. And usually what will come out of the end of that is a plan agreed by the parents, sometimes the child or young person and the school, of what each of those parties will do to support that child or young person to go back to school. Sometimes the court will accept those as what are called undertakings. So that's a promise to the court that the parents or the child or young person or the Department of Education will do certain things to support the child returning to school. So some of the things that we see in those action plans or promises to the court are parents enforcing rules about device use overnight, parents agreeing to take their children for a mental health assessment, for the school to agree to things sometimes as well, for a student to change classes if there's been bullying, for example, or if there's been an issue with transport for a family, sometimes the school will be able to support with transport options. Even in certain circumstances where there's been some bullying, because a student has not been in a position to be able to afford a uniform, providing a uniform. So it's really practical things to support attendance by really addressing the actual reasons why that child or young person isn't at school.
It's really good to hear of some of the reasons why, as it turns out, children are not attending school. And it's good to know that it's approached in that way by the Children's Court.
There are certain circumstances where evidence of non-attendance and the evidence in these conferences can be used in care proceedings.
And just so that people understand, care proceedings, when do they occur? What are they?
So care proceedings are when the Department of Communities and Justice have removed or assumed the care of a child from their parents and have made an application to the Children's Court for orders, which are usually seeking orders for parental responsibility for a child or young person to be allocated to the minister, which is where children are, as I said, removed from the care of their family and placed in out-of-home care.
So you mentioned before, there's duty lawyer on the day and legal aid is available to help people in these compulsory schooling order matters. Can you just give us an idea about eligibility? Like, can anyone get legal aid for that, or is there some restriction?
Yes, anyone can get legal aid if they're a respondent to a application for a compulsory schooling order in the Children's Court. So there is no means or merit test for either parents or children or young people.
Yeah, so in any financial circumstances, they can receive legal aid support and assistance for that legal matter.
Absolutely, yes.
Okay, great. And do you know if legal aid is also available in the criminal matter in the local court?
Yes, there is legal aid available for representation in prosecutions in education matters. To be eligible for legal aid, the applicant must satisfy a means test.
Yeah, it's definitely worth reaching out to legal aid if one of these matters come up for them or their clients.
Oh, absolutely. So legal aid also gets provided a list. We get provided a list of what education matters there are, both applications for compulsory schooling orders and prosecutions and the date that they're listed and the court that they're listed in. So as far as possible, particularly for compulsory schooling order matters, we are aware of when they are listed and we'll arrange a duty lawyer.
That's so good to know. That would be very reassuring as well, just for community workers listening.
Yeah, what we've seen across the state is that the issue around chronic non-attendance for children and young people that result in applications for compulsory schooling orders and result in prosecutions against parents rarely exist in a vacuum. So what we have seen is that there are really complex factors underlying the child or young person's non-attendance. So unfortunately, we're seeing the interaction of poverty, risk of homelessness, domestic and family violence, substance misuse by both parents and children and young people, mental health issues, and either undiagnosed or untreated or lack of support for disabilities, again, both for parents and children and young people, and lack of access to services, particularly in regional areas, that are all acting as barriers to attendance for these children and young people.
Yeah, sad as that is to hear, it's also not really surprising, is it? It's just, that there's a constellation of factors that could contribute to school non-attendance. I'm wondering, do these compulsory schooling orders work, or the prosecution process in the children's court, or the application for orders? Does that actually work to help children return to school and start engaging?
So there's really not a lot of evidence in relation to this. There was an audit in 2022 that basically said that there's not the evidence to support that it makes a considerable difference in terms of these children and young people re-engaging with school. There was recently a review which found a very similar thing, that there's really not the evidence to support the effectiveness of these applications. So really positive in terms of outcomes for the homeschool liaison program. And what it really identified too is exactly that there should be more focus on that real early intervention and identifying issues earlier and younger to then be able to prevent that chronic non-attendance.
How can community workers support people experiencing or at the threat of having children's court proceedings commenced about schooling? As a lawyer, are you seeing community workers involved in these matters, and what support do you see being really effective for these young people and their families?
I think it really depends on what the underlying reasons for non-attendance are, because it is different in every case, and it really is about supporting the children and young people and their families to address the issues that are leading to non-attendance. And what these families tell you are the support that they need and that you're able to provide. So for some families, what that might be is assistance with housing.
Is a letter of support relevant? Is it a matter of connecting them with local supports, or is it about communication with lawyers?
It's really what's relevant for that family. There is often a constellation of issues that are impacting on children and young people's attendance at school, and it's about identifying what support is required and who is best to provide that support. So it may be referrals, it may be working with families to be able to better advocate for themselves with the school around what the school is able to do to support a child's attendance.
Yeah, you mentioned homelessness and, there could be a need for diagnoses. It sounds to me like what would be useful for community workers to bear in mind would be some of the issues that you raised that can come up and be addressed in the conferences. So anticipating those, so things like referrals for mental health or drug and alcohol support, homelessness, domestic violence, addressing those issues.
Yes, support with domestic violence, absolutely. Safety planning,
Yep.
and putting in place supports for both the child and young person and their family. One of the other things as well is looking at alternative education options and supporting families to be able to look at what might be an alternative to a school, particularly for older children. So there are independent schools, as we talked about earlier, homeschooling or distance education. For some older young people, looking at options for apprenticeships or other types of learning like TAFE.
Yeah, great. So what's your main takeaway for the community workers listening?
It is really the right of every child in New South Wales and in Australia to have an education. There is overwhelming evidence that children who do not have access to education are much more likely to have poorer long-term outcomes. There is also a really strongly established link between interrupted school attendance and contact with the criminal justice system, either as a young person or later in life. This is really compounded for children who have other vulnerabilities, such as disability, socioeconomic disadvantage, and contact with the child protection system. And educational neglect is also a grounds for involvement by the Department of Communities and Justice.
And that involvement is about care, potentially care proceedings being commenced and children being removed from families into the care of the minister.
That's right.
Yeah.
Yes. And Aboriginal and Torres Strait Islander children are particularly at risk of interrupted schooling and subsequent involvement with the criminal justice system, and are also 10 times more likely to be removed from the care of their families by the Department of Communities and Justice. So my takeaway would be that if you are working with parents of school-aged children, to be asking them whether they're attending school, and if not, why not? Because providing support at that early stage before there is perhaps a referral to the homeschool liaison program, or before it gets to the point of an application being made to the court, is an opportunity to address those issues at a really early stage and get children and young people back to school without needing the intervention of the court.
Yeah, that's a really important message. Thanks, Carey.
You'll now hear from civil lawyer Brodie about school discipline policies, review pathways, discrimination issues, and more.
So we're speaking to Brodie Purdon. Brodie, can you tell us a little bit about your background?
Yes. Hi, Yolanda. It's great to be here. I'm recording on Gadigal country. I am a senior solicitor in the Children's Civil Law Service at Legal Aid. We help highly disadvantaged young people in Sydney and Dubbo who are involved with the criminal justice system. We've got a couple of caseworkers who work in our team with us. Very lucky to have them. So it's an interdisciplinary practice helping young people with civil law issues.
Okay, great. So today we're going to be speaking about school exclusion. And I know that you have some experience with this. I had a look at some stats and I was really shocked actually to see the rates of school exclusion. So in 2024, it looked like more than 1 in 10 high school students in New South Wales were suspended and over 100 were expelled. And there's another study that was also recent that tracked 72,000 New South Wales public school students over a decade and found that nearly 1 in 5 had been suspended or expelled at some point. And those rates accelerate in early high school. So most exclusions are happening in years 7 to 10, with about 71% of those cases happening during those years. And it disproportionately affects boys, people from regional and remote communities, and those from disadvantaged backgrounds. So it's a real social justice issue, and I'm really glad we have the opportunity to talk about it today. We can acknowledge that a lot of behavioural issues at school may arise from trauma, problems at home from DV or drug and alcohol use, or perhaps parents or children with undiagnosed or untreated neurodiversity, mental illness or disability as well. So before we get into school exclusions specifically, let's talk about discipline in general. So in New South Wales schools, what forms of discipline are allowed or not allowed?
In terms of discipline, so obviously back in the day, there used to be corporal punishment and, you know, people's parents or grandparents might be talking about getting the cane and whatnot. Obviously, that is out the window and we are not doing that in schools anymore. Teachers are quite restricted now in what they can do in terms of discipline. Generally, exclusion in one form or another is one of the main forms of discipline that is used in schools. So that could be exclusion from a particular activity, like we're all going to watch a film, but because you didn't do certain behavior, you won't be allowed to watch that film, and instead you'll have to complete this worksheet or something like that. And then ranging up to if you displayed certain behavior, not allowed to participate in lunch sports or PE class, or restriction of those kind of privileges, up to at the more extreme end, obviously there's suspensions, and then at the most extreme end, there's expulsions.
And I think we can all be glad that we don't have corporal punishment at schools anymore. I don't know if that was ever effective, but it certainly wouldn't be welcome in this day and age. So what about bullying? Let's just talk about that quickly. What should schools be doing if there's bullying happening at the school?
Bullying is such a complicated area. Schools should address bullying by taking every report really seriously. They should be investigating reports. So every time that a complaint is made, seeing what was involved there. They should be implementing their anti-bullying policy. So every school should have that, providing support for both the victim and the student exhibiting the bullying behaviour. Depending on what the kind of bullying is, immediately they could be trying to isolate the young person, so getting them away from the person who's exhibiting that bullying behaviour. They could be offering counselling. They could be taking restorative steps, so some kind of mediation where they get the two kids together and maybe the parents are involved, and there could be apologies and the shaking of hands and that kind of thing in an ideal situation. But it really depends on the circumstances whether that's appropriate or not.
Absolutely. And so what you're saying is schools should not be ignoring bullying. They should definitely be
not.
proactive to remediate the situation and make it safe for all concerned. And obviously it sounds like it's a support-based approach where they're going to be looking at what both parties need in that bullying scenario.
Yes, absolutely. Yeah. Recognising, like some of those things you said earlier, that challenging behaviours are often a result of trauma or disability. And so recognising that both parties need support in this situation. But ultimately, the number one principle guiding bullying policies today is taking every report seriously and investigating it.
That's very good to know. Okay, so now we're going to talk about school exclusion. So we've already touched on the fact that there are two kinds of school exclusion we'll be discussing, and that's suspension and expulsion. What are the legal issues that arise in these expulsion or suspension cases? I understand there's three main areas to consider.
I would say the three main issues are, firstly, breaches of procedural rights. So essentially, a student has the right to be heard and the right to a fair and impartial decision. So if they're saying the person who made this decision was really biased because of X, Y, and Z, then they might have not been afforded procedural fairness. So their procedural rights may have been breached. Say the second issue is breaches of policy. So, for example, not giving the child a disciplinary meeting before their suspension or expulsion to explain the reasons for that decision. So it might be that the suspension or expulsion was totally valid, but they didn't follow their own procedure in terms of getting there. And discrimination is another whole kind of separate issue.
Yeah, we'll come back to that later as well. So where do the rules about how schools expel or suspend students come from?
There is a legislative framework around this. Government schools are governed by the Education Act 1990 in New South Wales, which empowers the minister to control and regulate student discipline in government schools. And the New South Wales Department of Education suspension and expulsion of school students procedure is the primary source document for New South Wales government schools. Under the procedures, principals have the delegated authority to suspend or expel a student from their school. Non-government schools are a totally different kettle of fish, so we need to obtain and review the relevant policies applying for each of those schools. The majority of the clients that Legal Aid is dealing with are at government schools, and those policies are reasonably accessible online.
Thank you. So that's just through the Department of Education website, is it?
Yes, through the Department of Education website.
Okay, and just you were mentioning about procedural fairness before, thinking what might it look like in these cases? Would it be, so they've got the right to their side of the story, to have that heard, and then to know that, as you said, there wouldn't be bias or the decision would be impartial, and also the right to appeal potentially, is that right?
Yes, that's right. There is a right to appeal. So if a young person, a student's gone through that process, so they have been, for example, they've been suspended, they have that disciplinary meeting before the suspension goes ahead where the school explains to the student why they're being suspended, the reasons for it, and the young person has the opportunity to reply. And this could be a good opportunity for them to have a support person, their caseworker or a parent, to be there with them to support them in explaining their side of the story. Essentially, the main things are that the young person is told that they are being suspended, they're told the reasons for the suspension, and they're given the opportunity to give their side of the story. They should be given a letter from the school saying the dates of the suspension and when they're expected to return. And then when they are due to return to school, there's usually a return to school meeting, which is an opportunity for that student and their support person. So it could be their caseworker or a parent to be with them and explain what they need to reintegrate into the school community at the end of the suspension in the best way possible for them. So a short suspension is up to 4 days. Long suspension is up to 20 days. So depending on the length of the suspension, it could be a bit of a transition for the young person coming back into the school environment.
And what about for expulsions?
For an expulsion, similarly, it's really important that the young person receives notification of the expulsion in writing and has the opportunity to respond to that about the reasons why they say they shouldn't be expelled, if that is the case.
So if a young person receives a letter like that about suspension or expulsion, do they have to reply in writing, or do they get a meeting, or what happens then?
They're not expected to reply in writing. They do have this disciplinary meeting before the suspension or expulsion begins, and that's where they have the opportunity to reply verbally. It's good for them to have a support person with them, if a parent or a caseworker or a mentor is available.
Okay, so what can a family or young person or child do if that process that you've just described is not followed?
Yes, if they think that there hasn't been procedural fairness in their suspension or expulsion, they can apply for a review to the Department of Education. There are particular forms online that can be used to apply for a review, but it's essentially going above the school and to the Department of Education as an umbrella who's looking after all the New South Wales government schools and saying, look, I don't think this was fair. I don't think X, Y, and Z policy was followed, or I don't think I should have been suspended at all. And I want you to review that decision. And then you would say on that form what you want the outcome to be. So, I want the expulsion or suspension to be cancelled and I can come back to school tomorrow, or I didn't get my disciplinary meeting and I want that, or I didn't receive my letter explaining the reasons for my suspension or expulsion and I want to receive that, whatever it may be. A challenge with this for suspensions in particular, because a suspension can be 4 days, you might apply for a review, but by the time you get the result, the suspension may have ended. So in that case, the outcome that I would be seeking for a client would be that suspension is not recorded on their record, even though they have essentially served the term of the suspension.
Okay, that's really interesting. It's really good to know that that's an option to make that request, that it sort of be off the record, so to speak. So just in terms of safety considerations, because schools are balancing out not just the needs of that one particular student, but obviously the entire school community and safety for students and teachers. So what can you say about safety considerations in these kinds of schooling decisions?
A student can be suspended from a New South Wales government school for serious misconduct that puts the safety, well-being or education of others at risk or causes significant property damage. So I feel like the significant property damage, that's relatively objective. But I think serious misconduct that puts the safety, well-being or education of others at risk is quite a subjective issue and could really be quite discretionary. To one teacher it's something and to another teacher it's something else. I did have a matter where a student was suspended and wanted to apply for a review of that. And essentially he was just wandering around the school and he wouldn't go into his timetabled classroom. And he was suspended and we applied for a review of that. We said that it wasn't serious misconduct that put the safety, well-being or education of others at risk. And we were successful on that. So he did get the suspension overturned.
That's a good example. And so with that, did you just negotiate with the school or did you have to go above the school to the department?
In that case, we did the formal review process. So we submitted the form to the Department of Education above the school. They confirmed that the suspension had been removed from his record.
So let's go now to where a child has been or a young person has been suspended or excluded, getting them back into the school. So you mentioned there's a meeting at the end of a suspension before returning, and that's where they can bring a support person to transition back to school. But what about for expulsions?
Expulsions are a really difficult area. It depends on what the young person's educational goals are. With an expulsion, if a young person has been expelled, that's it. They can't go back to that school. So they have to look at alternative options. For some young people, that could be, looking into TAFE. It could be distance education. It could be finding an independent school. It really depends. But an expulsion is something very serious, and it is quite difficult for the young person. They can't return to that school, and they're quite limited in terms of returning to other government schools.
So what you're saying is they potentially might not be able to go to a government school and then be left in a position where they go to an independent school that requires a higher fee to attend. And then would that potentially exclude a lot of young people from returning to any school at all, just on the basis of limited financial means the family has?
Yes. In the few circumstances that I have had where my clients have been expelled and we haven't been able to review that successfully, those young people were offered TAFE or distance education.
So the Department of Education is obviously a government department. So does that mean you can go to court about these matters like we sometimes can for other government decisions?
Yes, technically, judicial review is an option in these matters. I think it happens extremely rarely, but it is important to know that that is at the pointy end one of the options for dealing with these kind of matters.
So when we're talking about judicial review, we're talking about administrative law principles. So grounds for judicial review include things like lack of procedural fairness or natural justice, unreasonableness of decision, or an abuse of power, like a decision that's made what we call ultra vires or outside of the bounds of the power of that particular decision maker. But if a family is wanting to go to court, there are real barriers to that too, obviously, because they need to find a lawyer who can do it. Legal proceedings can be really costly, and it's also a real risk that if they lose, they might even have to pay the costs of the other party, so the Department of Education. And often when we're in these situations, they might just be more focused on a practical solution for getting their children back to school rather than fighting the Department of Education, either getting them back to school or to TAFE, as you said, or one of the other alternatives. So it'd be a real last resort to go through the judicial review process. And also from what you've said, it sounds like if there's good grounds for returning a young person to school, that the Department of Education is quite willing to find solutions and negotiate to settle the matter. So we've spoken about a couple of avenues to challenge these kinds of schooling decisions. We've spoken about seeking review with the Department of Education, and we've also spoken about judicial review, which is going to court. But there's also another option, isn't there? People can speak to the New South Wales Ombudsman, can't they, about these issues?
Yes, they can go to the New South Wales Ombudsman. That is an option. In my experience, the New South Wales Ombudsman is interested in hearing complaints where something can be done right now to resolve the situation and both parties can come away happy. So if the young person is really unhappy about a particular aspect of their schooling, they've taken it up with the school hasn't done anything about it or hasn't responded in a way that the student's happy with, that may be a good opportunity to go to the New South Wales Ombudsman. So let's say, for example, this young person is really not getting along with their teacher. They don't like this teacher. They want a different teacher. That could be an opportunity. Go to the Ombudsman, and the Ombudsman may arrange a conciliation. So get the two parties in a room together and try to come up with some kind of solution where the young person and the school can both walk away happy. In that circumstance, or maybe the kid goes into a classroom with a different teacher or to a different school, or maybe they have that teacher 3 days a week and a different teacher 2 days, some kind of solution that works for everybody.
And is that process free?
Yes, it is free.
It's good to know, another option. And so the Department of Education review process is also free, isn't it?
Yes, it is free.
So what about behavioural issues that arise from a disability? On the Department of Education website, it links to a couple of documents, and one of them is the disability standards for education that they have to follow. There can be situations where a young person or their family might be hesitant. They may not want to acknowledge a disability, or they may not be diagnosed. They might not even want to go through the process of being diagnosed. What can you tell us about disability and behavioural issues that arise in schools because of disability?
Yeah, it is a really challenging area, I think, the intersection between disability and behavioural issues. We know that children living with disability can have higher educational needs or different educational needs to their peers. Occasionally, the young person's needs are really exceeding what the school can provide, and that imbalance can create really big issues. Purvis is a 2003 decision of the High Court where the majority ruled that expelling a student for behaviour caused by a disability was not necessarily unlawful discrimination if a non-disabled student with a similar behaviour would be treated similarly. So say I'm living with a disability throughout the day in the classroom, I'm just getting up and just yelling out for 30 minutes at a time. And as a result, my classmates can't hear the teacher and the teacher responds by sending me out of the room. If that behaviour is because of my disability, it is not unlawful discrimination if the person next to me who doesn't have a disability but is screaming out for 30 minutes at a time, if they're removed from the classroom for the same reason. Does that make sense?
Yeah, it does. So that decision, that's still good law, isn't it?
It is good law. It is. And it's quite controversial. I think it does really limit the obligations of the school to young people living with disabilities.
So in those cases where we know that the behaviour might be caused by a disability, but we know that Purvis is sort of in the way of potentially lodging a successful discrimination complaint, we'd have to look at those other things that you mentioned earlier, wouldn't we? Potentially looking at whether the school had followed their own policies and the disability standards, and also whether they had offered procedural fairness, etc.
Totally. So I'm not saying, that punishment is definitely appropriate. It may not be appropriate. And there are probably avenues for improvement or avenues for resolving that dispute with the school, but a discrimination claim may not be one of those avenues. So definitely can still take up a complaint, could involve the ombudsman, could apply for a appeal or review of the relevant decision. All of those things are still open.
And I suppose it would be case by case, wouldn't it? So there might be cases where actually what's described does amount to disability discrimination. So we need to still be aware that there are situations where we might still be able to bring disability complaints against schools.
Absolutely. Yeah. Definitely disability discrimination still comes up, but that case has limited it.
And similarly with race discrimination, I think, it's fair to say that there could be some issues with that in schools, and that behaviours could be targeted more in certain students from certain backgrounds. So individuals should generally seek some legal advice if they think they are being discriminated against due to their race or disability in a schooling setting. So what is unlawful discrimination anyway, Brodie?
Unlawful discrimination involves unfair treatment in key public areas based on protected attributes like race, sex, age, disability, and sexual orientation. So these things can absolutely happen in a school setting, and unfortunately they do happen in a school setting. If discrimination is involved, then the process is similar to all of the other ways of dealing with issues in school that we've mentioned, but you could also include complaints to external bodies like the Australian Human Rights Commission or Anti-Discrimination New South Wales.
Thank you for that information. It's really important to know about. So let's talk about case studies now. You did mention one earlier, but I think you have a couple of other ones up your sleeve that you could share with us today. I'll just mention one that came to my attention. So this is an example of one that was run internally by Legal Aid and related to a student who had been suspended, but with apparently an indefinite period. They'd actually stopped attending school for about 12 months, and they had tried to enrol in another school, but they couldn't because the original school had to approve it and had refused to do that, thinking that that child needed to be homeschooled. Eventually, we were able to get the young person back into school, and the matter had to go to the Education Legal Department first, and then after it landed with their legal department, it did resolve quite quickly, and the child was able to attend another school where the principal was well aware of the history and was really supportive actually and keen to move forward. So just before you go into some case studies of your own there, what is the situation where somebody's been expelled? You mentioned it's really hard for them to get into a school. Is there something where the prior school has to release them for them to be enrolled in another school?
Yes. My understanding is that just generally, if a student is enrolled in a New South Wales government school and they want to enrol in a different New South Wales government school, they need to be first released by that previous school. And that could just be if you're moving house, or it could be as a result of some kind of disciplinary action. It's mostly just an administrative process so that kids aren't enrolled in multiple schools at once.
Right. Okay. Yeah, that explains it.
Suspension and expulsion are technical terms that have meanings according to policies and legislation. But that might not necessarily be the same as the understanding that students have of those words. And so something that I have seen quite a lot is students coming in saying, I've been suspended forever, and in my experience, it's a bit of a misunderstanding where the student may have been suspended for a certain period. And then because of many other challenges that that young person might be having in their life, they haven't re-engaged with school. And so that attendance has just dropped off. And really sadly, I see this all the time where students disengage from school for a temporary period for whatever it may be. It could be a short suspension. It could be some other kind of upheaval in their life, sorry business, travel, whatever might be happening. And then that friction caused by that prevents a young person from getting back into their attendance and then leads to a really long period of non-attendance, sadly. The same, I think, about expulsion. So I have had some students coming to me and saying, I've been expelled. I had a family come and say that their 17-year-old, he was living with an intellectual disability. He was wanting to transition from year 11 to year 12 at a public school. And the family reported that he had been expelled at the end of year 11 and wasn't allowed to go back into year 12 because of his behaviour. So we gave advice around a disability discrimination claim. It was, possible because he was living with that disability, contacted the school, had a look at the records and determined that the client actually had been reasonably excluded. And a principal may expel a student over 17 years of age for unsatisfactory participation in learning. So this young person turned out had attended 12 days of year 11. And so the reason that they were not allowed back for year 12 was not because of their disability or their behaviour. It was just their non-attendance.
Yeah, so it can't always be overturned. Sometimes it is a reasonable decision. And yeah,
Definitely.
something to bear in mind when we're dealing with families. Obviously, we always want to hear their side of the story. And I'm sure there are many situations where it's correct to challenge the decision and see if it can be reversed. But then, yeah, obviously in some cases it is the right move by the Department of Education.
And that's what procedural fairness is. I think procedural fairness is having the right to know what the decision is that's being made and why it's being made and asking questions and finding out all the reasons. So that's totally fine for that family to go through that whole process.
Do you have any other case studies that you'd like to share with us?
Yeah, I recently was working with a young person who told me that he wasn't allowed to come to school unless he took his ADHD medication in the mornings. And I'm seeing red flags here. I'm thinking that doesn't sound like something probably the school is allowed to do. And so we looked into that, and something that the school can do is they might have a behaviour management plan going on with that young person, or they might suggest to the young person that he might be better engaged with his learning if he is taking his medication. And when we spoke to the school about that, it turned out that that was what was in place. So the school had suggested to him that he take his medication before coming to school, but it wasn't going to prevent him from coming to school. So we did a bit of meeting with the school and a bit of negotiation and bringing the parties to the table to talk about it. We were able to resolve that issue that he could attend regardless of his medication.
That is a great result. And isn't it interesting sometimes how the communication breakdown is really at the core of what the issue is, and having third parties come in to help can really support resolution of the process. So post reinstatement, so once young people are allowed back into school, often we do see if they do re-engage that they go on to achieve quite a bit of success and can turn their lives around. And as we heard from Carey previously, there is some really strong social science about the impacts of disengagement from school or school non-attendance for whatever reason. And it really is important that we do our best to support young people to be engaged while they're still at that early developmental stage. But I wonder now if you can talk about what role you think community workers can play in situations where a child or young person is at risk of or has actually been excluded from school. How can they support these young people and their families?
Yeah, I agree with what you've said, and I feel really proud of the work that Legal Aid does in this area, because you can really change a young person's life trajectory by getting them to re-engage with school. It's such an important juncture where a young person is considering whether to continue their education or step back from that, and the support that a community worker or another advocate could have in that space is so, so important. I think that major areas for community workers to assist students are in that communication piece. So if we think about what's happening, might be that the teacher is telling kid, and it could be a 5-year-old, it could be a 9-year-old, it could be a 16-year-old, and then they're taking that information back to their parent or caregiver, we can see how things can be lost in translation, and it could really help to have someone there to assist with that. I think that the key meetings, so the disciplinary meeting, which happens when a young person is advised of their suspension or expulsion, is a great opportunity for a community worker to be involved there, to support the young person to understand what they're being told, but also to tell their version. And I think the re-entry meeting, when they're finished with their suspension or they're coming back into school after a period of non-attendance for whatever reason that could be, is also a great opportunity for the community worker to be involved. They can hear from both sides what's needed for the young person to have a great re-entry and to be supported in re-engaging with school, and they can help make that happen. So it could be that they need transport every day. It could be that they're embarrassed that they don't have the uniform for school. It could be that they're hungry, they're not coming to school because they haven't had breakfast. Whatever that may be, I feel like that's a great area for community workers to step in and hear the needs and respond to them.
Yeah, those social supports are so important. If the basics aren't in place, it's really hard for young people to really care about school even, or feel that they can be comfortable in the school environment. So there's lots of room for social support, I think, from what you're saying. So when do you think one should seek legal advice about these issues?
I think that if you are wondering whether something that has happened to you is fair and you're wanting to change it, then I think that's a fine time to seek legal advice. If you have been suspended or expelled, definitely worth getting legal advice if you disagree about the reasons or want to know if that was fair or not. If you think that you may have been discriminated against, if you've been treated unfairly, definitely worth getting legal advice in those cases.
How can legal aid help young people and their families who might be experiencing some of these schooling issues?
Young people and their families can call Law Access, and Law Access will arrange an appointment for the young person and their family with a legal aid civil lawyer who can talk to them about school exclusion. Legal aid can help if access to primary or secondary education is curtailed in circumstances that give rise to an unlawful discrimination complaint, to negotiate with the school or make a complaint with the Department of Education. Or if the young person is in out-of-home care and so they don't have a parent or guardian to advocate on their behalf, and they need to appeal a decision to expel, suspend, or use restrictive conditions impacting that young person's access to education. So in those cases, we could help negotiate with the school or appeal to a local education office or the New South Wales Department of Education.
Mm-hmm. Thanks, Brodie. And the Law Access number, I'm sure many are already aware, but it's a free line and it's 1300 888 529. And if it's a matter where it doesn't fall into those categories you've just described where legal aid can help, say it's not unlawful discrimination or the child is not in out-of-home care, or they actually have a parent guardian who can help them, where else do you think they might be able to seek some help for schooling issues?
We're quite lucky in New South Wales. There's quite a few great community legal centres available for young people, and they're quite flexible on what they can do. So they often can help with things that we can't. Youth Law Australia is excellent. The Shopfront Youth Legal Centre is also really great. And Marrickville Legal Centre has a youth-specific lawyer. So all of those organisations, they're small, but they're very powerful.
Excellent. Okay, thanks so much, Brodie. Is there anything you want to say in finishing?
Anyone who's really interested in this topic, I commend it because I really think this is a great opportunity to make a difference in young people's lives. So thank you for your interest.
Thanks so much, Brodie. Really appreciate your time today.
Thanks for having me.
That's all for this episode. Thanks for tuning in, and special thanks again to Carey Pearson and Brodie Purdon for sharing their expertise with us. As always, you can check the description for all the links and resources mentioned in this episode. Law for Community Workers is produced by the Community Legal Education Team at Legal Aid New South Wales. If you have any feedback or want to collaborate on a podcast, email us at cle@legalaid.nsw.gov.au. If you haven't already, make sure you sign up to our Law for Community Workers alerts to receive updates about resources, webinars, workshops, and more. Remember, everyone's situation is different. What we've discussed in this podcast is information only and cannot be relied on as legal advice. It's based on the laws in New South Wales and is correct at the time of broadcasting but may change. If you or someone you know needs legal help about a particular situation, start with our team at Law Access New South Wales on 1300 888 529 or via web chat at legalaid.nsw.gov.au. Catch you next time.